were able to get the insurance to flip their decision and actually pay out $25,000 for damages.
Hi guys. This has pretty much been Jonathon Daily.
Moving on, Ostrich Briefcase case. I don't know if anyone has seen our post, but we did make a post on the Daily Law on our socials about an Ostrich briefcase. That's right. So in this case, what happened, without getting into too many details for attorney-client privilege purposes, a client was a tenant at a property and they had some pretty high-end clothing, pretty high-end articles of personal property. One of the most valuable was a $20,000 ostrich leather briefcase. So what happened in this case is they had renter's insurance and there was a storm and there was a leak in the roof. I think it was actually a hurricane, and the storm water came through the roof, went into their closet, destroyed a lot of their high-end clothing and the ostrich leather briefcase. So he submits the claim to his renter's insurance and they deny it for failure to mitigate damages, which is an actual defense that insurances often will implement as, oh, okay, well, it wasn't really destroyed, but your failure to take it and get it treated immediately is what really led to its destruction. However, we sent a demand and we had discussions with the insurance adjuster and we made the argument of proximate cause. There's case law on this in Florida, especially when it comes to insurance claims. It's the proximate cause argument that stormwater, which is a covered peril under the insurance policy, stormwater came through and that is the initial proximate cause. Proximate cause is another way of saying legal cause. So the proximate or legal cause of the damage and inevitably the entire ruining destruction of the ostrich leather briefcase was the stormwater. So as a result of that and our negotiations, we were able to get the insurance to flip their decision and actually pay out $25,000 for damages. So that was a win for us. So that is something for you to note. Proximate cause is a great argument when you're dealing with insurance claims in Florida. So don't let them try to tell you, oh, sorry, denied, stamp denied, just because, oh, failure to mitigate damages. Well, the original cause was from a covered peril and there's case law on this. Therefore, this claim should not have been denied and you could potentially have bad faith litigation, which insurance companies do not like. So please approve the claim, and of course they did. So that's awesome. For the latest in case updates, legal tips, news, and politics, make sure to like us on Facebook, follow us on Instagram and our other socials, and above all, subscribe on YouTube to get your dose of excellence on a daily basis.